All right, the court is going to call 2024 CR 009-869 State versus Fidencio Gonzalez. Can I have parties announced?
Lauren Espinoza for the state.
Tony Adonis on behalf of Mr. Gonzalez.
And are you Mr. Gonzalez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
There we are. There we go.
There is?
Yes,
Mr. Gonzalez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Ma'am.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
No, Your Honor, state moves to waive count 1 and proceed solely on count 2 of the indictment.
Any objection?
No, yeah.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. In count 2, you're charged with injury to a child, elderly, or disabled with intentional bodily injury as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in the prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with defenses?
Yes, yeah.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, sir.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, sir.
Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, sir.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 10 years in the prison. There's a $2,000 fine. State is opposed to your applications. They're taking in consideration 2025 CR 012507. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, yeah.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Oh, yeah.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Yes.
State, any evidence?
Yes, Your Honor, state offers state's exhibit 1 and all attachments.
Get no objection. Yeah.
And state, have you spoken with the complainant?
Yes, Judge.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, thank you. Oh, you all have the steps. All right, after reviewing State's Exhibits 1 and attachments with the, and viewing the video that was a part of the stipulations, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Counsel, would you like a PSI or?
Yes, sir.
All right, I need a PSI date. Is there a need for a TAP evaluation as well?
I don't think so, Judge.
And you said February when? All right, it will be February 2nd.
Thank you.
You're welcome. Once you sign the reset form, you'll be excused. I'll base my decision on any evidence that's presented to me.
Thank
All
you.
right, thank you. Yes.
The state got records from the state of Georgia last week that were uploaded recently. I have not seen those. The physical copy I'm starting to look at here in the courtroom, but it's at least 60 pages. Plus, the state did provide me with a CD with the alleged body cam of the officer. It's going to have 40 trillion terabytes of information, whatever it is.
40 trillion.
It's a lot.
It's 40, Your Honor, but it is 40 terabytes.
40 terabytes of information.
All right, so I'll have you all back here tomorrow. Once you sign the reset form, you excuse and counsel after reviewing that. If you want to file a motion, if requesting that it be excluded, the court will consider it.
Okay, we'll go for that point, Judge.
All right, thank
See
you.
tomorrow. Thank you.
All right, thank you for dressing appropriately for court. Once you sign the reset form, you're excused.
Have a nice afternoon.
Oh, thank you, you too. All right, who's next?
Yes, ma'am. I have Where's H3 by now? And this is only.
Michael Balderas. Hello. All right, today's plea deadline date.
Yes, Judge. We're asking the court for a short reset of the plea, or extension of the plea deadline. There's still some outstanding discovery that we're trying to resolve. My understanding is that it'll be ready later this week.
And Your Honor, it is in the state's possession. The issue is our e-discovery system. When defense puts in our JN number, nothing pops up. And so we have to keep passing back and forth the flash drive.
All right, Norma, recall this for final plea deadline date, December 8th. Yes. All right, thank you. Thank you for dressing appropriately for court. Who's next?
We have a gentleman who's agreed that he didn't find it, but
Who is it?
gentleman right here.
No, I didn't.
No? Oh, okay.
Judge Douglas, Mayor Coach. just-
Yes.
Can I have permission to go do the plea in Judge Robertson?
Yes. Anyone else ready?
Ready, Your Honor.
Who are we?
Lawrence Nose.
No?
Yeah, straight.
Ready? There you go. Our criminal.
Are you ready to proceed?
Yes, Your Honor. With just an explanation of a request for reset. Today is their first day here on this motion to revoke. In speaking to my client, he did notify me that he had retained Kimberly Bush as his attorney.
Mhm.
I did follow up with Ms. Bush for court right now, and she did confirm that she was hired. She apologizes to the court for not being here. She is under the weather. She is ill. She did request a 1 week leave of the courts for her to be allowed to send in her notice of retained counsel on this case, as well as his 2 indicted, 1 unindicted, and misdemeanor case as well, Judge. So being that I don't want to step on those of retained counsel, she requested that I request for the court a 1 week adjournment so she can get all those matters in order and That way I can close him out on my caseload once that documentation is done.
State, on Terrence Knowles, will you all be ready for a contested hearing on December 11th?
Mhm.
All right, let her know. This is going to be a contested hearing on December 11th.
Yes, Your Honor, I'll convey that over to her, and then I'll be on the lookout for her sending that notice in as well as the court.
All right, thank you so much.
Of course.
And counsel, the court received a request to reinstate a bond and recall a warrant on a case. I asked Ms. Ferguson to set it, but if you want to address that, you can address it.
The courtroom tension is palpable as Fidencio Gonzalez stands before the formidable Judge Stephanie Boyd. The charge is severe: injury to a child, elderly, or disabled person, a third-degree felony carrying 2 to 10 years in prison. Judge Boyd, in her characteristically thorough and authoritative manner, begins a meticulous colloquy, ensuring Gonzalez understands every right he is waiving. She emphasizes the high stakes of his application for deferred adjudication, warning that if he fails, he could face the full maximum sentence. The procedural drama unfolds as the state amends the indictment, proceeding solely on count 2. Judge Boyd leaves no room for error, questioning Gonzalez and his attorney on competence, understanding, and the voluntariness of the plea. She underscores the immigration consequences and the $2,000 fine. The state, however, is opposed to his application, hinting at another pending case, 2025 CR 012507, that weighs against him. Then comes the evidentiary hammer. The state submits exhibits and, critically, a video as part of the stipulations. Judge Boyd takes time to review the evidence off the record. When she returns, the atmosphere shifts. She finds sufficient evidence to convict Gonzalez, but defers a formal finding of guilt, granting his application for deferred adjudication. However, her ruling is not the end. In a move that underscores her strict control and desire for a complete picture, Judge Boyd orders a pre-sentence investigation, PSI, scheduling a follow-up hearing for February 2nd. She explicitly states she will base her final sentencing decision on any evidence presented, leaving Gonzalez in a state of suspended consequence. His freedom remains conditional, his future in